Welcome to RIN's podcast, talks about confiscating assets in the EU. In this episode, we focus on mutual recognition, procedural aspects and protection of fundamental rights. Regulation EU 1805 of 2018 is based on the principle of mutual recognition, which requires harmonization of national legislations to be effectively applied across European territory. Despite the gradual alignment of criminal legal systems among member states, there is no true European criminal law because each country applies its own system, principles, and criminal laws. These divergences make it challenging to recognize criminal measures adopted elsewhere in a state. In the realm of confiscation and seizure, the difficulty in harmonizing laws is even more evident. Hence, it was necessary to adopt a binding EU act. Eurojust conducted an initial analysis on the effectiveness and functioning of the Regulation 1805, and the collected data are not encouraging, especially when confiscation measures are not based on a conviction, such as Italian preventative measures. There is difficulty in implementing mutual recognition in such cases. Italian preventive confiscations are a highly effective tool in combating major criminal groups by depriving them of their illicit gains. Preventive measures are based on the concept of the dangerousness of assets and aim to prevent a crime rather than punish it. The autonomy of the preventive procedure from the criminal one is hardly understandable in other European countries. Nevertheless, more states are recognizing the need to curb the expansion of illicit assets in the market and are introducing types of confiscations preceding criminal convictions, non-conviction-based confiscation, into their legal systems. Currently, preventive confiscation is the subject of a heated debate, even before the European Court of Human Rights, regarding its compatibility with fundamental rights. Indeed, the debate is fueled by Consideration 13 of Regulation 1805/2018, which outlines its scope through the concept of proceedings in criminal matters. This autonomous concept of EU law still lacks clear boundaries, making it difficult to understand which of the numerous confiscation measures fall within its scope. Regarding the protection of fundamental rights, Regulation 1805 is very attentive to this aspect. Cooperation among member states presupposes mutual trust, which implies that all European states respect fundamental rights, rule of law, principles of legality, and proportionality of sanctions. The new proposed directive on asset recovery confiscation of 2022 aims to enhance the confiscation powers of states by proposing norms that, among other things, expand the role of national offices for asset recovery and management, and allow the application of confiscation to a broader range of crimes. For the first time, attention is also given to the social reuse of assets of illicit origin. The Italian model is extending to other member states that tend to sell rather than to reallocate confiscated assets back to society. In recent years, the allocation of assets from criminal activities for social purposes has become internationally a felt need, generating significant interest in the topic today. Speaking on these topics will be Professor Andreana Esposito, Associate Professor of Criminal Law at the University of Campania Luigi Vanvitelli, and leader of RIN's research project, and Dr. Maria Vittoria De Simone, prosecutor of the National Antimafia and Antiterrorism Directorate, and a member of the Board of Directors of the National Agency for Seized and Confiscated Assets.